All right, the court will hear argument.
Judge, in addition to all of this, I do have a copy of Ronald's father, Ronald Wayne Allen's death certificate, so that we know that this is an honest
Oh, no,
regarding this man. He was an Army veteran, and
all right, and I reviewed the document, and counsel, you're an officer of the court.
all right,
All right,
thank you,
thank you.
Judge. Regarding this matter, Your Honor, we're here today on this motion to reduce bond filed on behalf of Ronald Allen. Mr. Allen is currently sitting in the custody under conditions that neither reflect his flight risk nor serve the purpose of public safety. We think that this incarceration, in fact, functions as an instrument of oppression prohibited under the Texas laws and the United States Constitution. Under the Article 17.15 of the Code of Criminal Procedure, the court must consider the following factors. The bond must be sufficiently high to ensure appearance. It may not be used as an instrument of oppression. The nature and circumstances of the offense must be considered. The accused's ability to make bail must be regarded, and the future safety of the community and any alleged victim must be weighed. Further, Article 1.07 guarantees that bail is a right, and Article 17.09 permits this court to modify bail at any time prior to his conviction. The Eighth Amendment of the U.S. Constitution prohibits excessive bail, and the 14th Amendment's due process clause requires this court to avoid pretrial detention solely on the basis of poverty. The application to this case is that there's been no physical confrontation and no victim impact regarding this case. The underlying facts of the case would show that Mr. Allen was in a private conference with his custody lawyer at the time of the alleged offense. We want the court to understand that this was an emotionally charged conversation because of a long custody and visitation battle with his ex-wife, and his family attorney had only been retained for several weeks. The statement that he made that gave rise to the terroristic threat charge was made outside the presence of any alleged victim, and there is no indication that Mr. Allen took action to carry out any of his threat. The case was documented by the San Antonio Police Department and the Fusion Center, but it resulted only in an information report, not an arrest at the time. No firearm, no plan, no attempt, just words spoken in the distress amid his ongoing family court litigation and the emotional duress. Notably, the complainant himself, the attorney that he had, called the SAPD out of an abundance of caution, but he was not in fear. The compelling personal circumstances on this case are substantial because of in addition to the low risk nature of the alleged offense, Mr. Allen has experienced profound personal hardship because his father, Ronald Wayne Allen, passed away while Mr. Allen was incarcerated. He has been unable to grieve properly or to attend final arrangements. Family tragedy only worsens the financial burden of a high bond. We think that Mr. Allen needs help to grieve, to deal with these charges. It would also help for him to be able to manage his defense. You heard today from Evelyn Allen. She's the defendant's mother. She's a woman of modest means who has established her financial resources through her marriage with her husband, who recently passed. She's exhausting her financial resources trying to help her son, and she has testified that Mr. Allen has longstanding ties with the community, has never failed to appear for court, and she is willing to supervise him personally, and that the current bond amount is financially oppressive to their family. Your Honor, we are not asking the court to ignore the concerns of public safety, only to apply the law fairly. There's been no evidence that Mr. Allen poses a threat to any person if released. He does maintain there is a civil protective order between him and his prior lawyer because he's the one that made the report and the outcry regarding the terroristic threat. But he would abide by that protective order substantially. There is, however, evidence that the current bond amount is far beyond his means and his family's means, and we believe that it's unnecessary to secure his return to court. We are requesting at this time that the court consider reducing Mr. Allen's bond to a reasonable amount or releasing him on appropriate pretrial conditions, which may include GPS monitoring, counseling, or any mental health evaluation if the court deems such conditions necessary. We believe that this would align with the Code of Criminal Procedure, Article 17.15, as well as the constitutional safeguards designed to protect the rights of the accused while preserving public safety. From where I'm sitting, I recently became his second criminal defense lawyer, and it is a difficulty for me to prepare for a complicated, what's likely a complicated trial regarding this case. I've filed motions to suppress and a motion to dismiss this charge, but I'm not here on that today. I'd like to get my client released under a reasonable bond so that I can prepare and have him prepared for those hearings outside of the jail.
All right, State.
Judge, we believe that the bond has been set in a sufficient amount regarding public safety. Regarding the testimony that you heard from today, it sounds like, well, the mother does have limited needs. She does have several items of collateral available to her, and there's also this untapped resource in the defendant's own personal belongings, financial resources, and bank accounts that they've neglected to speak about for privacy reasons, as testified to by her. And then regarding just the flight risk, I mean, he does have ties to locally Texas and Louisiana, so we would ask that you keep the bond amount at 100,000.
Judge, I guess if I may, with respect to the family resources, they are. She doesn't have a lot of access to a lot of the funds that might be available in their normal circumstances if Ronald's father was alive. Just weeks after Ronald was incarcerated or jailed, this man died. And so we believe, and Ms. Allen has advised me, that a number of those resources and properties are going to be tied up in probate in the coming weeks.
Well, let me just explain something. I don't believe that someone should be required to put their home up for collateral to make somebody else's bond. So I'll just lay that there. That is gambling to put your home up. Yes. Because the bondsman will take your mother's home if you fail to appear. Mm-hmm. So this is the court's issue. So I've read defense, I've read your motion. And in your motion, you put that Judge Hortek found that your client wasn't a threat to his son or the community at large, and that there will be a protective order regarding his ex-wife.
Yes, there is, Judge. And
that he will be allowed to proceed with his visitation rights. So I don't understand. On the civil side, they said he was going to have his visitation rights. It's going to be supervised, and they wanted a psychological evaluation. I don't understand how we go from that to now he's before me on a charge of terroristic threat. And Mr. Allen, I want you to know I don't take any of this as true because I haven't heard any evidence on the facts. The reason why I bring that up is because, as you stated, counsel, part of the things I consider in a bond reduction is safety of the community. So in this case, safety of the community would be based upon the indictment, the community at large, and also the protective order that your ex-wife has, her safety as an individual, but then the community at large, based upon the exhibits that the state had me read, which was part of the police reports. So that's the court's concern.
Well, Judge,
and has he done a psychological evaluation? Has that been done, or was that completed?
No, Judge. The order coming from the civil case, from my understanding, I'm not a civil lawyer, but my understanding is that final order in that Satzer modification that was filed by the ex-wife and was litigated while he was in jail through Judge Fortick. That is pending as far as the order being signed.
Okay.
There are judge's notes that indicate what I mentioned in my motion, that the protective order against the son was denied. There is, I think there's other ways to secure the community other than a $100,000 bond. I think a GPS or any kind of tracking would be able to secure compliance. And if there's a bond condition that prohibits his contact with either the complaining witness in the underlying terroristic threat case, or who I believe did get his own protective order, and then also a protective order, or rather a bond condition that prohibits his contact with the ex-wife, and ask him to remain in the jurisdiction. I think that can mitigate some of the risks of him not coming to court.
All right. And state?
I would just reiterate my prior arguments and then the testimony regarding his prior arrest.
All right, this is what the court is going to do. With regards to your other motions that you filed, the motion to dismiss and the motion to suppress, we'll set those for hearings and y'all confer. And I would like those hearings set as quickly as possible because that may end up addressing whatever issues are here. But Mr. Allen, I'm going to deny the motion to reduce bond. I'm going to order that there be partial GPS for employment only. GPS fees will be waived, and there'll be a referral to Center for Healthcare Services. So if y'all would confer with Ms. Ferguson on having that motion to suppress heard counsel and also your motion to dismiss. And so if y'all speak to her, she'll tell me what's the date that y'all both can agree on, and we'll make sure that hearing is heard.
Thank you, Judge.
All right, you're welcome. Thank you, counsel. And just come back to me once you get a date. Yes. State. Megan?
Yes.
Norma is telling me that his next court date is July 28th. Would you all be ready?
All right, let's talk about that. This hearing centered on Ronald Allen's motion to reduce bond was thoughtful, layered, and full of nuance, exactly the kind of legal back and forth that gives insight into how these decisions really get made. Judge Boyd did an admirable job navigating a pretty complex set of circumstances. She was calm, careful, and transparent about what she considered relevant, particularly community safety and the conditions of the protective orders in place. Mr. Allen's attorney came in strong, laying out constitutional arguments about the role of bond and how pretrial detention shouldn't become punitive. He even backed that up with specifics. No violence occurred, no weapons were found, and the original report by the family attorney wasn't accompanied by a formal arrest. They made a pretty compelling case that Allen's incarceration was functionally more oppressive than protective, and the testimony from Evelyn Allen, his mother, helped paint a fuller picture of the personal toll. On the other side, the state kept its focus squarely on public safety and financial means. They didn't dispute that the family had limited funds, but they argued that other assets and accounts hadn't been fully disclosed. The state also pointed to the original reports and protective orders, arguing that the current bond was appropriate. What stood out was Judge Boyd's balance. She wasn't buying into a narrative of guilt, but instead focused on the legal standards for bond reduction. She even clarified she wasn't making findings on the underlying facts, which is both proper and important. While she ultimately denied the motion to reduce bond, she did partially grant GPS monitoring for employment and waive those fees, which felt like a middle ground, still cautious but non-inflexible. The courtroom itself stayed respectful throughout, even during some emotionally charged discussions about family tragedy and psychological evaluations. All participants, including the judge, attorneys, and the defendant, conducted themselves with civility, and you could tell this wasn't a routine motion. It was a tough call, and whether you agree with the outcome or not, the process was handled with care. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone,